Hello, my name is Charlie Russo. I'm on the faculty at the University of Dayton in Dayton, Ohio. I'm sorry I can't be with you in person, but I'm happy to present for you on tape. My talk, as the initial screen indicates, is on religious freedom in a brave new world, how leaders in faith-based schools can follow their beliefs in hiring. I chose this topic based on my long and enduring interest in matters of church and state. The picture, by the way, is of course the United States Supreme Court, and I generally start presentations with it because our daughter, an accomplished amateur photographer, took this picture when she worked as an intern in Washington, D.C. some years ago. In recent years, important issues about religious freedom have arisen in a variety of arenas that impact perhaps dramatically on the way in which leaders in faith-based schools can hire for mission. That is to say, how they hire to get people to share the values of their institutions. These questions come up because, again, in recent years, the Supreme Court has handed down a number of decisions that are somewhat conflicting, to say the least. In 2011, for example, in Hosanna Tabor versus the Equal Employment Opportunities Commission, a unanimous Supreme Court upheld a ministerial exception under Title VII of the Civil Rights Act of 1964. This law allows religious employers to make the decision alone as to who satisfies their religious needs as workers. But on the other hand, some incipient threats to religious freedom may be arising in light of some Supreme Court cases from earlier this year. More specifically, in United States versus Windsor, the Supreme Court struck down the Federal Defense of Marriage Act, and on the same day in Hollingsworth versus Perry, the court refused to allow proponents of Proposition 8, which defined marriage as being between one man and one woman, to intervene to defend that statute or that proposal. I mention these cases in juxtaposition because on the one hand, the Supreme Court upheld religious freedom, but on the other hand, the outcomes of these cases may well impact the religious freedom not just of religious employers, my primary topic, particularly in elementary and secondary schools, but in religion in a variety of areas, something admittedly beyond the scope of this paper. As many of you are no doubt aware, Title VII is the most significant federal anti-discrimination statute dealing with employment. In relevant part, and I will skip over reading it since it's in the paper, it prevents discrimination on the basis of an individual's race, color, religion, sex, or national origin. Of course, my concern here is religion. Under Title VII, there are 4 exemptions when it comes to religious employers. The first is a kind of threshold exemption, and it applies to institutions with 15 or more employees. This exemption does not often apply to faith-based schools, particularly in the Roman Catholic Church, because religious elementary and secondary schools in the Catholic Church are typically part of their larger parish corporations, which would bring their total number of employees up over 15. The second situation, or the second exemption, deals with where with religion, sex, or national origin is a bona fide occupational qualification necessary to the operations of that particular business or enterprise. In the entire paper, I trace a number of lawsuits, particularly those involving where female teachers were pregnant out of wedlock, led to their being dismissed, not just in Catholic schools, but in other Christian schools. As an aside, I might mention that I oftentimes refer to Catholic schools, and I do so primarily because most of the cases involve Roman Catholic schools, or I also speak of Christian schools because almost every case, in fact, every one that I have found, dealt with either a Roman Catholic or Christian institution. The litigation would, of course, apply to schools of other faiths, such as Islam or Judaism. The third exemption, and the one that led to the most recent Supreme Court case, is referred to as the ministerial exception, sometimes the McClure exception, the case in which it was first enunciated. And this applies, to quote the statute, to a religious corporation, association, educational institution, or society with respect to the employment of individuals of a particular religion to perform work connected with the carrying on of its activities. The Supreme Court has addressed this exemption in 2 different cases. In 1987, Incorporation of Presiding Bishop versus Amos, a case involving the Church of Jesus Christ of the Latter-day Saints, the Supreme Court upheld the dismissal of an engineer, thereby extending the reach of the ministerial exception to employees who were not involved in religious activities. More recently, in 2011, in something of a surprise, a unanimous Supreme Court upheld religious freedom and ruled that religious employers alone had the authority to decide who should be able to work in their schools. The underlying litigation involved a Lutheran school where a teacher was out ill. And although the case applied primarily the Americans with Disabilities Act, the language is similar enough to Title VII such that it's linked in this regard. Under this exception, courts are generally, but not unanimously, unwilling to intervene in disputes over whether teachers have lived in their public-private lives, so to speak, in a way that comports with their faith. So that again, there are cases where teachers are pregnant out of wedlock, marry people who are divorced, or live lifestyles that are antithetical to what the churches for whom they work believe. However, these same courts are typically more willing to intervene in matters that are more secular in nature, such as allowing employees to file discrimination claims based on age, or in a majority of instances, to litigate under state law over whether matters may be subject to collective bargaining, as long as they are lay in nature rather than religious. The fourth application applies to institutions, and again I quote, that in whole or in substantial part are owned, supported, controlled, or managed by a particular religious corporation, association, or society, or if the curriculum of such school, college, university, or other educational institution is directed toward the propagation of a particular religion. This allows faith-based institutions to hire based on their religions, to use the term I mentioned earlier, to hire for mission. So that if a school wanted to say all religion teachers must be members of their faiths, as long as the policies state that and apply it consistently, then they ought to be exempt from any kind of discrimination. A few thoughts and reflection. Again, there's much more detail in the paper that will be published. As important as it is, in my opinion, for the courts to grant deference to religious employers, the trend in litigation seems to be moving in a way that is less respectful of religious freedom. I mention this because, for example, in Windsor, the case involving the Federal Defense of Marriage Act, Justice Kennedy wrote, and I quote, that supporters of this, in brackets, the Federal Defense of Marriage Act, acted with malice for the purpose to disparage and injure same-sex couples. While perhaps there were some who did have that position, it strikes me as inappropriate to have such a broad-based claim against those who sought to defend the notion of marriage as being between one man and one woman. Against this rhetoric from a member of the Supreme Court, it makes me, and I know others, wonder where do religious employers stand? A possible answer may come from a lesser-known case during the same past term called Agency for International Development versus Alliance for Open Society International. In this case, the Supreme Court ruled that the constitutionality of a condition for receiving a subsidy, such, for example, as a tax deduction for people who donate money to religious institutions, depends on whether the condition imposed by the government defines or reaches outside of the institution's programs. In other words, it appears that based on alliance, public officials cannot impose requirements on religious organizations that would change their very natures. More specifically, an argument can be made, and it remains to be seen, whether religious employers would be obligated to alter their doctrines or moral teachings to hire individuals who do not live by church dictates. Again, litigation in the future will perhaps give us more information. With this, I turn to the final substantive part of the paper and briefly offer 7 recommendations for practice. The first is that educational leaders, whether at the diocesan level, in systems as highly organized as the Roman Catholic Church, or at the school level, as in many Christian schools that are freely associated, should offer ongoing professional development activities. These activities should be for both administrators and teachers so that they can become better aware of the interplay between their own church's teachings and the impact of civil law. A second point is related. Leaders, again, whether at the diocesan or local level, should seek to work with officials at local colleges and universities, asking those that are working in preparation programs for teachers and administrators to offer instruction on the relationship between civil and religious law. Third, when leaders in Catholic schools working with their attorneys prepare job descriptions and the like, they should distinguish clearly between ministerial or religious work and activities that are purely lay. A related fourth point, if religious employers wish to include matters of this sort in their policies, whether it deals with premarital sexuality or pregnancy out of wedlock and or marriage to individuals who are divorced or not Catholic, then they should do so clearly and unequivocally, making it explicit that these are the rules by which they will expect people to abide. The fifth point is a pretty common suggestion that employers should work on the advice of their attorneys, but not just any attorney. If possible, hire attorneys who understand both civil and religious law. It may cost a bit more financially up front to have people with such expertise, but they do exist. I do not practice, but do, for example, have a Master of Divinity degree and a law degree, and there are a number of people like myself who do practice. Putting a little bit more time up front, it seems to me, will save difficulty down the line should controversy arise. A sixth item for employers in particular is to create policies that are consistent with biblical norms and church teachings on a wide array of employment matters. And seventh, again, a fairly typical recommendation, is that religious employers should regularly update their employment policies, typically once a year, to make sure that they are up to date with trends in the law and where things may be going. Beginning to round out, one of my favorite quotes comes from Francis Bacon, who says, "Knowledge is power." The more that employers and religious institutions are aware of these points, that I think the more sound their employment decisions will be, and the greater the likelihood that they could survive any litigation, particularly when charged with discrimination on the matters that I just presented to you briefly. Again, in sum, to the extent that leaders in faith-based schools are aware both of civil law and their own church teachings and try to carry these out in an authentic and realistic fashion, then hopefully they will survive litigation. I thank you for listening. Should you wish to reach me, you can do so by email at crusso1@udayton.edu. That's crusso1@udayton.edu. Again, thank you for listening, and I hope you have a great conference.